My name is Ryan Mears. I'm your Marion County prosecutor, and it is great to see so many familiar faces here today. I feel very fortunate every year to be a part of the Community Justice Academy, and the topics that we're going to cover are truly driven by the feedback that you give us each and every year in terms about what you're interested in as it relates to the criminal justice system. And we've got some really good topics this year where we're going to cover a couple of different issues. And I'm very excited about today's topic, which is the grand jury and the grand jury process. And hopefully we can shed a little bit of light about what we're doing here. I see some familiar and famous faces walking in right now. Come on in. Yeah, that's a great looking shirt you got there. This is the 15th annual Community Justice Academy, and many of you have been with us for most, if not all, of the years. And so we're very grateful for your continued support. And we look forward to the conversation that we are about to have. But I'm going to let a couple more people filter in.
I didn't see there was room up here.
And just a reminder, this is the first of 3 sessions. And for those of you who attend all 3 sessions, you will receive a t-shirt. And so we look forward to handing out those t-shirts on the last day and kind of sharing a little bit about what we learned this year and maybe what you'd like to hear about or learn about in the future as it relates to the criminal justice system. So welcome to the Community Justice Academy. A couple of housekeeping things. We have drinks in the back of the room. We have snacks in the back of the room. And if anybody needs to use the restroom, they're behind those doors back there. In addition to that, we are going to have a question and answer session at the end of today's presentation. And so if you have any questions, please hold on to those until the end of our discussion today. And with that, I'll get us into our initial topic, which is the topic of the grand jury. And I want to start with just who's heard about the term of a grand jury, and does anybody know what a grand jury does? Kind of. What shaking? Maybe not. You look like you want to tell me what a grand jury is. Tell us what a grand jury is. It's what? They indict people. They absolutely indict people. And you know how do they indict people? Do you know? By probable cause. So probable cause is the standard for indicting people in front of a grand jury. And so the way a grand jury works, though, is the prosecutor can convene a grand jury and they will call people in to testify. And then 6 members of the community will determine whether or not if there is probable cause for a crime to have been committed. And so many of the witnesses that you would see called at trial would be called during the grand jury process. One important note or caveat to the grand jury process is the defendant absolutely has a right to testify during a grand jury, but they don't have to. They have the option or the opportunity to decline to testify, and their attorney does not get the opportunity to ask questions. And so it is led almost entirely by the prosecutor's office and the grand jurors themselves, because the grand jurors themselves are allowed to ask for questions. They can ask for certain witnesses to appear, and they can also ask for different documents that they say might help them make a determination as to whether or not probable cause existed for a crime. And so that is one of the ways that we can file a case in Marion County. The overwhelming majority of cases that we file in Marion County are not filed through the grand jury process. They're filed when a police officer fills out a probable cause affidavit. They say these are the things that occurred, and then based on what the police provide us with a probable cause affidavit, we then make a charging decision, and assuming a judge signs off on it saying there's probable cause, that's how most of the cases in Marion County are filed. We do utilize the grand jury in a number of different types of cases. And does anybody have any thoughts or ideas on when we would use a grand jury?
When the death penalty may be sought?
Sure. When there's a case of do you consider filing the death penalty or not, or maybe a higher profile case or incident, that can certainly lead us in front of the grand jury. Anybody else have any thoughts? Yes.
Police action shootings.
Police shootings, certainly.
When you don't know if you have enough evidence.
When you don't know if you have enough evidence, absolutely. Yes.
Homicides.
For homicide, sure. I think go ahead.
White collar crimes?
White collar crimes, absolutely. And first of all, you guys are great. You guys have your work cut out for you in terms of doing the presentation. I'm not sure how much you're going to inform people, but one of the things that during the grand jury, why we would put something in front of the grand jury is it is our chance as prosecutors to get feedback from the community on our case. And some of the cases that we put in front of the grand jury involve cases of self-defense. Because at the end of the day, when you talk about issues of self-defense, it comes down to a question of reasonableness. Was the person's actions reasonable under the circumstances? And I will tell you, probably the biggest evolution I have seen in terms of the public's perception of fear, where I've seen really that standard change the most has been in the issue of self-defense. I started off as a deputy prosecutor in 2006. And what would have qualified in self-defense in 2006 is dramatically different than what qualifies as self-defense now. I think people are more likely and more willing to give people the benefit of the doubt when they make the decision to use force. And so a lot of times when we're presented with cases where someone's saying, I absolutely did it, but I was in fear, and I think my actions were reasonable under the circumstances, ultimately, who determines what's reasonable or not are people from the community. And so the grand jury is a wonderful opportunity to put that in front of people from the community to help us define, was this reasonable or not under the circumstances? That's one situation where the grand jury has been an incredibly useful and helpful tool for us at the prosecutor's office. The second scenario, and the great thing about the grand jury, is it is the one time that we can compel people to testify before we have made a charging decision. So if the police try to talk to you and you don't want to talk to the police, legally there's not much they can do. And sometimes there are people in our community who are involved in crimes or criminal activity that maybe don't wish to participate in the criminal justice process. And so one of the things that we can do, if we can get them served with a subpoena, is we tell them, you are legally required to come in and tell us what happened. And they have to answer our questions. And so the great thing about a subpoena is it's not an invitation, it's an obligation. You have to appear, and it gives us the opportunity to get people in front of the grand jury who maybe otherwise would not ordinarily cooperate. With the assistance of a judge, we can now get people into the grand jury room and kind of hopefully tell us exactly what took place. And so those are two of the most typical scenarios in which we are involved, or we send cases in front of the grand jury when we're having questions of reasonableness, where we want the community to help us define what is reasonable under the circumstances. And number two, when we have witnesses who are maybe not as cooperative as we would initially like or hope. And so those are two of the circumstances in which we utilize the grand jury. Now, it's important to note that the grand jury process is deeply rooted in our criminal justice system, and it is deeply rooted in what takes place around the country. If you are indicted or if you are charged with a felony in the state of New York, you have to go through the grand jury process, meaning that they will convene a grand jury, they will have people from the community come in, and they have to indict you for a crime in order for you to be charged with a felony in New York State. That is much different than the state of Indiana, where we don't necessarily have to have live testimony. A police officer can write something down on a piece of paper called a probable cause affidavit, and you can be charged with a crime. And so it's a much different process in different states in terms of how we can ultimately get to the place where we have the opportunity and the ability to file charges. In California, they have something called a preliminary hearing where the witnesses are brought in. But unlike the grand jury process, which is secret, the preliminary hearing process is an open court, meaning anybody can attend, people come in, they testify, and then a judge makes a determination as to whether or not the state can proceed with charges. Again, a significant difference from what we have in the state of Indiana, where we can do it by information and the facts kind of alleged by the police based on the probable cause affidavit. So a number of different states do it a number of different ways as it relates to the grand jury process. It is an incredibly important process because it allows you to compel witnesses. It allows you to get community feedback in terms of where you maybe stand with the case. But it also is a great opportunity for prosecutors to get a better understanding of what's going on. It's your opportunity to acquire information, develop information, and then you're also being led by people from the community. And so you have a pretty good sense of what your case is, because you get that instant community feedback of people saying, I need to hear from this witness, we would like to see this document, and you don't get that in a trial. And so that's one of the beauties of the grand jury process. And it's something that we utilize from time to time. But we can only do that if we have incredibly talented prosecutors in our grand jury division, which we do. And two of those talented prosecutors are going to present to you here today, Amy Jacobson and Ann Frangus. Amy Jacobson right here. For those of you who don't know, Amy Jacobson is a big Nebraska Cornhusker fan. And they're doing okay this year.
Not doing too bad, yep.
Were they 5-1?
Only one loss, yes.
Okay, only one loss to Michigan, so Amy's doing really well. But she's been a prosecutor for more than 10 years. She's worked in all different areas of our office. Really focuses on the homicides in our special crime unit, which really try to focus on some of the more complicated homicide cases that we have. Has a lot of experience dealing with self-defense cases and kind of sorting through exactly what is reasonable or not. And so she's going to help us walk through the grand jury process. And Ann Frangus, who has no allegiance to any team, is here. And she also has more than 10 years of experience, also in our grand jury unit, and also not only has the homicide experience, but spends a lot of time on white-collar crimes and helping trying to determine what that process should look like for acquiring information, and then how do you synthesize that information where people can hopefully digest it and try to make sense of what they are looking at. And so with that, I will turn it over to Amy and Ann, and then at the end, we will have a question and answer session. So give it up for Amy and Ann.
All right, we will get started, even though Prosecutor Mears and you answered most of the questions in our presentation, but we'll go ahead and give this a shot. I'm Ann, again, for those who maybe couldn't see us. We will put this here. And this is Amy. And like Prosecutor Mears said, we both work in the grand jury and special crimes unit. So a lot of our day involves working with the investigators that work in our office, as well as working with the homicide division of the various local police departments on cases that need to be screened, cases that just happened and are active investigations. So that is how we spend the majority of our day. But today we're going to focus on the Marion County grand jury system and what does that look like? What does a grand jury look like? How does that process work? Because it is something that people don't often get a good inside look at. So when we say the word grand jury, in our office, we mean the entire division. And that division is made up of a number of investigators and support staff and prosecutors who all work together on a variety of generally white-collar cases, but occasionally some different types of crimes. But really, the grand jury is made up of Marion County residents. So it's made up of people who are selected to be on the Marion County jury. And we'll talk a little bit more about what that service looks like. But as Prosecutor Mears mentioned, there are two different ways that a case is brought, that charges are brought against a person. The first one is that the investigator drafts a probable cause affidavit. They write up a summary of what they have learned through their investigation, what witnesses have told them, and they present that to our case. To our office. There are screening prosecutors who read through that information. They may listen to statements, watch videos that may be involved, and then they make a charging determination at that point. They determine if there is criminal activity present and what those charges should be. And then they file a charging information along with a probable cause affidavit with the court. The other way that charges can be brought is with a grand jury indictment. Like you mentioned, the investigation is brought before the Marion County grand jury, who gathers at our request. They listen to that evidence, they ask questions, they examine documents, and then they deliberate. And they make a determination on whether there is probable cause for certain offenses that they have been presented. And if there is a sufficient number of grand jurors that agree, then they sign an indictment. And that indictment is essentially, it operates the same way as the charging information, but when it's filed, it is not filed with a probable cause affidavit. That determination of probable cause happens in the grand jury room. So who is the grand jury? So we request that a grand jury is called into session we do this every quarter. We always have a grand jury available to us in Marion County. They are impaneled using the same process as a regular jury. So if you, I'm assuming a lot of you have been jurors before. Has anybody gotten a jury summons? So it would be the same process. You would get a summons in the mail, and you would come in and you fill out a slightly different specialized questionnaire. It has some questions about law enforcement, just to get kind of their ideas about certain topics. And then we all go into a courtroom, we lock the door, we're in there with the judge and the court staff, and then the prosecutors from our office, as well as our support staff, and we do a voir dire. It's a little different than a regular voir dire process when it comes to a regular trial where, you know, we're talking about one specific set of facts. Oftentimes, when we are impaneling a grand jury, we don't even know what we're going to present. We don't know the types of cases that they are going to hear. So we tend to try to do a more generalized voir dire. We often have a case that may involve a law enforcement officer. We may have a case that involves public integrity or certain kind of financial offenses. So we generally know that, okay, we're going to talk about certain types of issues just to get an idea on where they stand. We are still trying to do that, the same goal of with a regular jury, that we're looking for people who can listen to the evidence, they can be impartial, but it is a little more difficult when we don't know specifically what topics we should ask them about. Once a grand jury is selected, 6 grand jurors, 1 alternate grand juror, the court then selects, or we suggest that they volunteer if they don't want to be selected, a 4-person and a clerk. The 4-person kind of guides the deliberations, and the clerk maintains some of the paperwork and reads some of the oaths, signs some paperwork as part of the process. To be a grand juror, it's very similar to being a regular juror in Marion County. You have to be a Marion County resident, you have to be a U.S. citizen, and you have to be 18 years of age. Oh, sorry, we have 2 computers that aren't necessarily in sync, so I have to remember to do this. How are they selected? So we talked about that. So the voir dire process, the backgrounds, their beliefs, their involvement. Another interesting one that we don't normally have to get into when we're talking about a regular jury is scheduling conflicts. Usually for a regular trial, we know where we're all going to be for the next 1 to 3 days. It's really hard to anticipate what your schedule may be. We are not here to ruin anyone's, vacations, make their spouses or partners mad at them for having to miss something. So we definitely try to get those dates ahead of time. We try to work with those people because nobody wants a grand juror present who'd rather be somewhere else. But sometimes scheduling conflicts do prohibit a person from being on a grand jury. We have times where we have, people who are in a really busy season of work, or maybe are taking a month-long trip or something like that. Like we talked about, grand jury matters are secret. What happens in the grand jury room cannot be disclosed. And this is part of the statute that no person except within the lawful discharge of their duties or upon written order of the court disclose the nature or substance in grand jury testimony of any decision, result, or matter. And that's an oath that we take very seriously, both within the office. It's also something that we'll see is read to the various witnesses and targets that come before the grand jury.
Sure. And so that can be hard for the grand jurors once they come in, because once they hear all the things, they want to talk about it, right? And they sometimes have feedback for their community leaders that they'd like to pass along, but they can't. Because anything that happens within side of the grand jury room is secret. And like Ann said, that's something that we take very seriously, and ask that they take very seriously as well, because it is a crime, and that's not why they're there to commit crimes, but it's to determine if a crime happened. So when is a case presented? Like Prosecutor Mears said, one of the biggest reasons is whether or not it's appropriate to present the evidence. And see what the community thinks about that. Is the case is there enough there? As a part of our jobs, like Prosecutor Mears said and Ann said, is that we do screen cases. So we have an idea of what probable cause means to us and what we think it takes enough to file those charges. But sometimes cases fall right on that line of whether or not it is self-defense, or whether or not there is enough, or whether or not a witness that we think is believable would be believable to the community. And so that it could be another reason that we take the case to the grand jury. Or like Prosecutor Mears said, individuals are just not cooperative. This can be either through what we call an investigative grand jury, where we don't ask the grand jurors to make a decision, just to listen and to ask questions, or it could be to present the whole case to the grand jury. And so that would be when or why we might take a case to the grand jury. We are the ones who make that determination of whether or not it goes, our office takes it to it or not. There's not a hard yes or no, this has to go before the grand jury in our system. The other thing that our office does is that with the grand jury is that we have subpoena power, not only to subpoena people to come before the grand jury, but also to subpoena documents and records as part of our investigations. And so part of that, when investigating white-collar crimes, we need to see the bank records before we can determine whether or not a crime's happened, right? So we certainly a search warrant is a valid way to obtain records if you file a search warrant, but one, all grand jury matters are confidential, and two, the level that the need to get the records for is lower for a grand jury subpoena than it would be for a search warrant, because the grand jury subpoena is just a reasonableness test. And that is because we are just beginning our investigation by getting those records. We don't necessarily have to have evidence that a crime is ongoing. Just we have to have a suspicion and a reasonableness level in order to obtain those documents. So that is part of one reason why the grand jury exists in Marion County. We review those subpoenas daily, and review those and submit those to the judge for them to make a determination on whether or not something's reasonable to ask for records from various companies that may not want to just hand over someone's banking records or phone records or things like that. This is a court order to turn them over as part of an investigation. So if you find yourself on the other end of a grand jury, you are what we call our target. Our target is the subject of our investigation. We can issue a subpoena to you, but if we take something before the grand jury and ask them to make a decision, we have to let them know that is going to happen, because they have the right to appear before the grand jury to testify if they wish. Now, if a subpoena is issued to them, we send them what is known as a target letter. So if you are undergoing an investigation, we would send you a letter saying you are the subject of the investigation. Here's your opportunity to come and talk to the grand jury if you so wish. Within that letter, we tell them that they are the subject of it, that they have the right to consult with their attorney and may be assisted by the attorney in the room. And if they can't afford an attorney, the court can appoint one for them. So one thing that we'll talk about a little later is that the judge for the grand jury rotates quarterly, just like the grand jurors rotate quarterly, but each different judge in the Marion County system oversees it for a quarter, and they review all the subpoenas. They get any court asks and make any decisions of what we ask them for, and also if a witness needs to have a witness or a target needs to have an attorney appointed for them, then we can ask that judge to go through the process of appointing an attorney for them. So that's who we would ask there. And if they are the target and do choose to testify, their attorney can be in the room. Their Fifth Amendment right still stands. Just because they're invited to come does not mean that they have to. But if their attorney is present, they can't speak. And they can't ask questions. They can't stop them from answering anything. But if there is a question on which a target is being questioned by a prosecutor and he wants to take a break to consult his attorney, then he certainly has the right to do that. And to take a break, they would go out in the hallway, have their conversation, and then come back in and decide whether or not to answer that question. But there's no objections. There's nothing that the attorney can do other than be there to be able to consult outside the presence of the grand jury, should they so choose. And they do also take an oath of secrecy when they're inside the room, so that they don't know, they cannot go out and tell the world what happened within that room. Additionally, they can also not present a defense to what is going on inside the room. And at that point, I think I'll say that we do take our job seriously in that we try to be even. Because there is no defense presented, we feel the obligation, and we cannot advocate one way or the other. We take it very seriously to present what we think are the issues that they would raise, that a defense attorney would raise, that is relevant for the grand jurors to consider. So we don't just present the state side and leave out anything that would be exculpatory or pro target or pro defendant. We present all of the evidence to the grand jury. And we do that because we don't want to end up with an indictment that once the defendant steps in the room and presents their defense, the case is gone, right? So one reason that we take something to the grand jury is self-defense, right? So we present that as part of the whole case so that the grand jurors know what evidence would come in if an indictment happens and if we go to trial.
Yeah. I'm going to add one thing to that too. Has everybody heard that phrase that it's so easy you can indict a ham sandwich, right? Like people joke about that. But like Amy said, we don't want a case that we can't ultimately prove in court. If we go through the trouble of doing a grand jury, if we put a target through that, if we put witnesses through that, we don't gain anything by manipulating the system and getting an indictment on a case that we then can't ultimately prove beyond a reasonable doubt. Because regardless of the probable cause standard for issuing that indictment, once the case is filed, whether through an indictment or a charging information, our burden remains the same for the ultimate, trial phase, which is beyond a reasonable doubt. So we definitely try to keep that in mind by also not presenting evidence that we would not reasonably expect to come in at trial. So say we have something great that we know about a case that may be very persuasive, but if we know that the rules of evidence would not allow us to use that at trial ever, we're not going to present that to a grand jury because, again, we're not getting a realistic picture of what that case would look like.
And so how a grand jury proceeds after a target letter is sent, we say we're meeting on this day. The proceedings advance. We pick 6 grand jurors and an alternate. They are all present in the room if they are available. But like we said, scheduling happens and they're on call for a whole quarter. So we often don't have all 7 who are available to be there. However, we do need to have 5 of them to have a quorum. And 5 of them there, 5 of the jurors are necessary to issue an indictment. So they don't all have to agree, but 5 of the jurors have to agree in order to issue an indictment. The court and the prosecutors, us, are the legal advisors of the grand jury. So there is no judge in the grand jury room while we're presenting a case. It is simply us and our staff and any witnesses that are called before the grand jury. But we are the legal advisors. So like I said, we take that seriously. We present the evidence to them, and we also guide them in what is legally available inside of a courtroom, right? So if they ask a question that would never be able to be asked in court, we step in and don't allow the witness to answer a question like that. Oftentimes, and as anyone who is sitting here, they want to know about the past and what, if you're sitting on a jury, you want to know what happened in the past. Well, oftentimes that's not able to come in court. And so we don't allow them to ask those kind of questions. We rephrase their questions often into a way that are able to be allowed in court. And so that's what our role as the legal advisor is. We are always in the room, or we can't always be in the room except during deliberations. That is no different than a regular jury. The recording is turned off and it is private in there so that the grand jurors have the opportunity to deliberate in secrecy outside of our presence. We subpoena the witnesses to come and testify, and at the end of each witness, the grand jurors can ask questions that haven't already been covered of each witness. And we make sure that our foreperson reminds us in case we forget to ask if the grand jurors have any questions. We ask them to make sure that that everything's covered before we release a person from their subpoena, because once a person's released from their subpoena, they don't have to come back. And so because of that, we make sure that everything gets answered inside that room at that time.
Does the target have a right to ask the witness any questions?
The target is not allowed to be in the room except if they choose to testify.
Only for testimony?
Yep.
And only while they're testifying.
Yep.
Okay.
And so this is the room where it happens. Anna
I
dared
want-
me to sing it, but I did not choose to take her up on that. But this is the room where it happens in our office, and from there I'll let you take over.
Thank you. I was very thrown off when I first started doing grand juries because, you know, Ms. Jacobson and I, we have tried a ton of jury trials in a regular courtroom where we have, 12 jurors sitting in a row, and we walk and we talk to them, but we're not allowed to really interact with them except during jury selection. And from then on out, we have to pretend like we don't know who they are. That's so different than what happens in a grand jury. And I love this process. It feels so collaborative with the community to get feedback. It feels like everyone in the room is working on the kind of the same purpose, which is to determine what the decision is at that time. So this is how the grand jury takes place. It's a conference room in our office. We have chairs for the jurors. The prosecutor doing the questioning usually sits at one end of the table. The witness sits on the other. There's a television screen that you can't see in this photo right behind the witness where we show the various exhibits that they may be looking at. Our court reporter, Faith Phillips, sits over there and records it and keeps track of the evidence, just like takes place in a courtroom. Everything is recorded. We don't have a judge in the room, but the judge is sort of on call. If there were issues, then we can call on them to weigh in and give us advice. But generally, we run this process by ourselves. And so because everyone is just sort of sitting around the table together, when it is time for that questioning at the end of each witness, the jurors are asking questions. We may have follow-up questions. The witness themselves may, pipe in with things that we hadn't quite asked yet, because really the purpose of this is to gather that information. And, as you asked, can the target be in the room? And the target isn't in the room because it's hard to differentiate and think we're not talking about a defendant at this point. There isn't a case yet. This is the before that part. This is when the detective is writing his probable cause affidavit. That's the same thing that we're doing at this time. We're just doing it with you, members of the community. And so that is what takes place in this room. We then leave them in. We also have the perjury and obstruction of justice statutes written very large on the wall just to remind people when they're testifying that those are potential outcomes if they were not to be truthful or withhold evidence. So as we kind of talked about before the deliberations, there are statutory guidelines. We are not just making all of this up, even though sometimes it feels like there should be more rules because we're very used to a courtroom having a lot of rules. But we must identify on the record who each target is of that investigation and each offense that the target is alleged to have committed. And they don't have to select every offense that we've presented. They can select all of them, one of them, none of them, whatever that they seem is appropriate. So we try to present a large, gamut of options of crimes that we think may be present with the facts that we have. So what is our role? As Amy said, we are the legal advisors of the grand jury. So we are reading the instructions, we're guiding the process, we're asking the questions that we think that they need, but we're also explaining the law at times. Some of the laws that are applicable in cases are difficult to understand. And like all things in law, the answer is usually never yes or no. It's often maybe, or it's a gray area. And so there are laws and definitions that are provided to the grand jurors to help kind of guide their deliberations, but we may explain that. If they have questions, well, what does that mean? Then we're able to answer those questions. And again, we present the facts, we present the law, we instruct the grand jurors, and again, there's no advocacy. The grand juror's role is to ask questions. And usually the first grand jury that a new panel does, people are kind of quiet until one person asks a question. And then it really develops and then it becomes, like I said, just a very collaborative information gathering process. We have some jurors that, we have a hard time keeping them to hold off on their questions until people are finished talking because they love the process. I don't know that we've ever had a grand juror leave and say, I did not enjoy that. Most people are like, how do I get selected again? I loved it. And so it is it's a very fun and interesting process. This is one of the beginning instructions that they receive and that we read to them. And I think it's kind of important because it really kind of outlines what their primary goal is. The Constitution and the statutes of Indiana make them the judges of the law and the facts, and you may determine the law for yourself, but it doesn't mean that you have the right to make, repeal, disregard, or ignore the law as it exists. And these instructions that they'll receive, and again, those are outlines of what those target offenses mean, any legal definitions, and any other laws that may apply. And then in your investigation into the facts, it's your determination on whether or not an indictment should be returned, and it's their decision only. The burden of proof, like we talked a little bit about, it is probable cause. It is not beyond a reasonable doubt. And again, with the instruction, but we have here the definition of what probable cause means. A probable cause has been defined as the existence of evidence that would lead a reasonably prudent person to believe the target is guilty of committing the criminal offense or offenses here for their review. And again, additional guidance that they need to make those determinations based on the facts that have been presented. So that is the burden. But again, we are mindful of the fact that our ultimate burden, should an indictment be issued, is beyond a reasonable doubt. That does not go away whether or not a person is indicted by a grand jury. The indictment. So for the valid indictment, you must have at least 5 jurors concur. It is then signed by the prosecutor or deputy prosecutor, and it must be endorsed with the phrase, a true bill. We did a little research because what does that even mean? And I love to know the meaning of words and where they came from. And it's not as exciting as you would have thought. It's from medieval England, and the crown would put forth a bill of an allegation of someone's offenses, and people would sit, the grand jurors would sit, and they would make a determination. If it was true, they would write true on it. And if it was not, they would write no. And that is where now when a bill or an indictment is issued, it must say true bill, or it will say, if they sign no bill, then there's no bill, no indictment is issued. And then it must be signed by the foreperson of the grand jury or the 5 members of the grand jury. There are times where the foreperson may not be in agreement with the others. And so there is a mechanism for that to be signed and completed, even if that person doesn't agree. Like we kind of talked about earlier, a grand jury is always impaneled. They serve a term of 3 months, and the judges rotate as well. Jurors are paid a nominal fee. It is not a lot. So people often, just like in a regular juror, do bring up the financial burden that it may put on them, and so we do talk about that during the selection of the grand jurors. We do provide food if you're deliberating, and a little refrigerator if you bring your lunch. So we're happy to accommodate the best we can.
And water and coffee all day.
Water
long.
and coffee all day. Snacks, we try to take care of them. And we provide the reports to the court regarding the work of the grand jury. So there is something that is produced at the end of a panel to let the courts and the public know what that grand jury has done during that time period. There occasionally can be special grand juries. These are called by the court if necessary at our request. We've had a couple situations where that has happened where, say there's an offense where both sides have perhaps done criminal conduct. It would be very difficult to ask a person to make a decision about the culpability of this person who also is alleging criminal conduct against this person. And so we have called a special grand jury where one grand jury will focus on one case, and the other grand jury will hear the same evidence, same witnesses, but different targets. So the target of one will be the witness in another. And so that way they're able to make that decision without that sort of uncomfortable having to decide necessarily if one person has committed an offense rather than the other. They have the same powers and duties as a grand jury. And occasionally we can extend grand juries. Some of these investigations may take a long time. Some may start as an investigative grand jury where we are not asking them to make a decision, and then it morphs into or becomes one where we are going to present a case. And so we are able to extend a grand jury if we need to, because obviously we would like the same people to be hearing all of the evidence to make that decision. I don't know, I lost the clicker.
Further.
Oh, there it is. I lose things a lot. So there are 3 key types of grand juries. These are the main kind of ways that grand juries are presented. We have the civilian target. So this is where, like we talked about, a homicide maybe. There's a citizen, a non-law enforcement person who is alleged to have committed a crime in some capacity. And so we will do an entire presentation of the facts of that case, and the grand jury will make an indictment on whether that person has, if there's probable cause that they committed that offense. The next type, again, the investigative grand jury, not a decision making request at that time, but we are asking the grand jurors to listen, to ask questions, to compel that person to provide evidence that they probably don't want to do. And I know you probably have seen that on the news, that oftentimes they'll talk about cases where it's really difficult to get people to cooperate in investigations for a huge variety of reasons. And then we also do, as somebody mentioned earlier when Prosecutor Mears asked, grand juries for law enforcement officers. When a law enforcement officer has discharged their weapon in the course of their duties, whether they're striking someone or not, whether that person is injured or passes away, that's often a case that we will present to a grand jury. Because in reality, that type of a case is really usually just a self-defense claim, but just having been exercised by a police officer. So we have a couple sample cases. Obviously, we can't talk about cases that have actually gone through the grand jury because those are secret and we're not allowed to talk about them. So we've selected a couple cases to kind of show you what that would look like if that case were presented to a grand jury. So with a civilian grand jury target, how this all works, we email the grand jurors, we call them, we say, we need you Tuesday and Wednesday. And they'll come in, we give them coffee, and we welcome them, and then we begin our recording, and we begin with presentation of the case. We start by identifying the case, identifying the targets. We introduce the case. We confirm that there is no knowledge of any of the witnesses or the facts, because a grand juror who is selected for that empanelment may not be the best juror for a particular case if they know someone, they've heard of someone, they super followed a news story. So because we don't have to have all of them there and only need 5, then we can excuse a juror if we need to. And then we begin by calling witnesses. So when a witness takes the stand, we read them their rights and duties, which basically are that, you need to tell the truth about what happened here. We tell them about the guidelines and rules of a grand jury and about how everything must be kept confidential or it is a crime that you can be charged with. And then one of our grand jurors reads them an oath and swears them in. And then we begin that questioning process. So this particular case is a homicide that took place in the hallway. Well, the victim was found in the hallway of an apartment building. And there was also a trail of blood leading to a particular apartment building. I'm going to skip ahead here because I thought my word slides were first. So we'll come
There was
back
one.
to this. What?
There was one.
There was one? Did I miss it? Oh, there we go. So the first witness in this grand jury is usually the detective. So the lead detective, the lead investigator will come and they will walk through the grand jurors with the evidence that they have recovered and what they have learned through their investigation. We usually keep this person sort of on call because oftentimes after a grand jurors listen to the detective and then they listen to witnesses, they then will have more questions for the detective or maybe some follow-up. And so we can recall a witness, usually the detective, for more information because our ultimate goal is that the grand jurors have all of the information that they need. So in this particular case, October 15th of 2024, victim Vince Smith. I changed the names on this case, just so everyone knows these are not the actual names on this case. But this victim was shot twice. He was pronounced deceased. The police again arrived. They learned of the possible blood trail leading to apartment 2. The residence is locked. There's no response. So the detective would then be telling the jurors about how he applied for a search warrant. The crime scene was located. There's a disturbance. It appears to have been in the apartment. And then these are the evidence that is recovered: 3 fired bullets and 7 fired cartridge casings, as well as a witness who was on scene. I think one thing that's kind of important to talk about is at trial, we would not be able to get all of this information out through the detective. There are no evidentiary rules necessarily in a grand jury. So the detective wouldn't be able to talk about things that he didn't see on his own, that he didn't do. Often we have crime scene because they're the one that collects this evidence. So, but he can talk about reliable hearsay in a grand jury. We can play the audio of witnesses who maybe gave a statement to the detective, but for whatever reason, it's not appropriate to bring them in for the grand jury. So then now we have our photographs. So the victim is lying here in the hallway. And it's probably kind of difficult to see, but there is blood on the carpet that leads them to that apartment 2. When they open that door, they see that the apartment appears pretty disheveled. Looks like something has happened there. The evidence that was recovered here in the hallway, the victim. And then these are the crime scene cones that were placed by the crime scene technician as they began to collect evidence. And those are those various things: blood on the entryway, shell casings that were recovered that indicate that a firearm had recently been fired there. That's the part that's ejected from the firearm, as well as several fired bullets were recovered as well. So the detective is going to lay all of this evidence out for the grand jurors. This was found at this scene, and I just think this is interesting. Does anybody know what this is? Yeah, it's a playing card. Has anybody heard of these cards?
Yeah, so they distribute these decks of cards that have cold cases on them, and they're often distributed in like prisons.
Yes.
So that to compel people who may know something to come forward. But they're
Yeah, did everybody hear that? They're decks of cards that are handed out usually at prisons, and they have information about cold cases on them, as well as a tip line, so that way they're hoping to get them into the hands of people that maybe know something. This apartment building was vacant in the process of being shut down, so there were a lot of unhoused people that were staying in there. A lot of people had recently gotten out of prison. And so I just thought it was interesting because I've listened. Does anybody listen to that podcast? It's called The Deck. It's done by local podcasters here, and they do the stories that are on the decks of cards that are handed out. And so it's really a pretty interesting, I just thought it was interesting that one was found at the scene. So we then will call in witnesses. So in this case, witness one, Jack Jones. Again, these are real witnesses. I changed their names, but he was in the apartment across from apartment 2. The doors open and he sees the victim arrive with another individual. The victim had a gun. He heard that words were exchanged and several gunshots went off. 4 people were in the apartment, and he describes them by their nicknames. Nut, Michi, the person who ultimately is the target, and Cookie. The nicknames in cases are phenomenal, the nicknames that people go by. So it's always really fun to read all of those. And it's also a good exercise for the detectives to try to figure out who all of these people are.
And which nut they're talking about.
And which nut? Yes, there's often, there's a lot of Michis. Michi's a pretty common name. If your name has anything with an M in it, sometimes it's Michi. So he describes that the defendant, the target, was a tall, medium complexion, low fade haircut. He knew that he was recently released from a long prison sentence. He was shown photos of other people in the apartments, and he IDs Michi as someone he knows. He's in fear, and he's not going to identify who was the actual person who shot. Okay? This is very, very common in criminal cases. It's very, very common in homicides. We were talking about people that are all living in that same apartment building. It would be very, very difficult to identify the person who lives in the next apartment over as being the person who committed this offense. Detective Clark, again, he learns from district officers who are very familiar with the building who other witnesses may be. They ID Nut as a known squatter at that apartment, and they locate a person who matches the target and learn that that person was recently released from prison. So they're starting to identify who this particular person might be, or at least someone that they definitely want to talk to. 3 weeks later, the defendant, the target, is stopped in a vehicle being driven by Michi. And again, this wasn't a case that went before the grand jury, so excuse my constantly going back to defendant, because that's what we're used to on a case where someone has been charged. But when they have not been charged, they are a target. A 9mm Taurus pistol was recovered in the car that the target was located in. Michi was in the car, and he is charged with the possession of that gun, which is an interesting twist in the case. The search warrant was obtained for DNA swabs and photos of the defendant as target. Detective then continues to speak to new witnesses, and he learns that the gun found in that vehicle did fire the bullets and the fired cartridge casings in the apartment. So now we've got some of the people that we heard were in the apartment. We have the gun that was fired in the apartment. Still don't really know, don't have anybody IDing the target as necessarily the shooter. So I jumped ahead. There we go. So there is things that were found in the car. There were narcotics found in the car, and there was the firearm that was found to be the gun that fired the casings and that fired the bullets. So eyewitness number 2 is Nut. He brought the victim to the apartment that day to sell stolen goods. He says that he entered the apartment and gunfire ensued shortly thereafter. Victim was suspected of stealing from the target previously. He says that the people in the room are Nut, Michi, the target, Cookie, and the victim. And he identifies the target as a shooter, and he is shown a photo array and identifies him. The next witness is Michi. He is the person that was charged with the gun. He was in the apartment too with Nut, a person named RG. Dex could be the target and the victim. Was in the bathroom with the target doing drugs, knew of the target's gun being stolen, and the target thought the victim did it. So now he's giving us a motive. He's giving us a reason that this might have happened. The target sees the victim and he shoots, and Michi tells us that the target then dragged the victim into the hall. Everyone fled, and he is also shown a photo array. That's next slide. Okay, so the conclusion of the grand jury, then once all that evidence is presented to the grand jury, and do you see how you would have a lot of questions with these facts? Right? Can anybody think of like things they would want to know? Like there's some inconsistencies maybe, all kinds of things that you could ask. And the jurors love it and they dive right in and they ask those hard questions to the people that are sitting there. We then make a closing statement. It's not a closing argument. We just sort of recap the evidence that has been presented. Maybe make sure that if there's something that we think is particularly notable that they may want to consider, we can point that out. Perhaps there's video or audio or something that we want them to see again or hear again or make sure they know how to find. So we'll go over that. We explain any law. Again, the self-defense law, we'll go over that. We'll go over what that means. And again, no advocacy. We read the instructions that tell the grand jurors how to conduct deliberations, the explanation of target offenses, the explanation of the law, any necessary definitions. Oftentimes, like the self-defense statute has the definition of serious bodily injury, right? That could mean something very different to you than it means to you, than it means to you. But there are legal definitions of what those terms mean to help guide the grand jurors. And then they deliberate. We take away their phones, their smartwatches, their computers, and we close them in the room to go off and deliberate. Here, will you do that? Like get a drink.
Yes. And so at the end, once they have considered all of the evidence and just made what their decision is, they can either issue a true bill. If they are unanimous, the fourth person is the only person that needs to sign it. If they are not unanimous, but five of them agree that an indictment should be issued, then those 5 people would sign the true bill. If only 4 people agree, if that's not enough, and that's a true bill, or that's a no bill. And so there would be no indictment, and they would sign under that law. If there is an indictment, it is written up like any other charging information that you would ever see on the news that we would file under any other case. However, the thing that they were there to determine is probable cause, right? So there's no probable cause affidavit that also gets filed with the court because the grand jury has reviewed all of the evidence and come to the conclusion that there is probable cause. So that is the main difference of the paperwork that you would see filed on a grand jury indictment versus a charging information that was reviewed by a prosecutor and filed without a grand jury. If there is no indictment, the case is complete and it remains confidential. The only thing that gets filed is a report to the court saying that the grand jury considered it and that no bill was returned. Again, all the things that we've talked about already of why we might present this. Self-defense issues, factual issues. One thing in this case that I know of that was an issue for us was that every single witness that testified or that was there only talked after they were given a deal, right? And so do you as the grand jury find them credible knowing that they got a deal? So that would be something that you would have to consider about whether or not you can believe them, knowing why they are testifying. And we would present that evidence to the grand jury so that they can consider that. That's not something that we're going to hide because, again, we don't want to have to try a case where we are not going to be able to advance that beyond a reasonable doubt if we know things that will be presented in court. So the sample case number 2 is a law enforcement grand jury target. We do these often, unfortunately, but we do. This set of facts that we're going to talk to you about is a case that is true, did happen, but did not go in front of the grand jury. The officers were cleared by our office, and the defendant was charged in this case with 3 counts of battery with a deadly weapon and 2 counts of resisting law enforcement. So that is something that we as prosecutors have to do and look at, is both sides of the incident of a police action shooting or an officer involved shooting. We have to look at the actions of the person who was shot by the police and also the actions of the police, and determine whether charges are appropriate on either side. So in this case, we made that determination, but it is a case that I will say was would not have been inappropriate to go before a grand jury, but I think we looked at all the facts and just went ahead and made a decision. But this is similar to something that would be presented to the grand jury. So again, all the same things that would have happened to in the civilian grand jury happens in a law enforcement grand jury. In this case, we would bring in the CERT detective who is assigned. The CERT is a critical incident response team. Those are more than likely going to be a homicide detective that gets assigned to the scene, and it goes out there and is your detective. But again, he is going to be able to testify to things that he wouldn't necessarily be able to testify to in court, simply because hearsay and reasonable hearsay or reliable hearsay is allowed, and the rules of evidence don't necessarily apply. But we do consider those and make sure that we follow them as closely as possible when presenting cases to a grand jury. So in this case, Officer Foster was located a stolen black Ford F-250 pickup truck near East 19th and Arlington and attempted to stop that shortly thereafter using lights and sirens. The truck stopped, and as Officer Foster started to get out of his vehicle, the driver of the truck, later identified, reversed and rammed into Officer Foster's police vehicle. That caused the airbags to deploy and heavy damage to the vehicle. This was Officer Foster's vehicle there on 19th. A chase ensued across the near-ish east side of Indianapolis and ended on Poplar Drive, where two officers came into contact with that same F-250. They were each behind it during the chase. One kind of cut off the truck to start with. The other pulled up close behind. The officer that was in this vehicle, you can see, has been damaged. It was also rammed by the suspect during the chase, or at the end of the chase. And he had a not insignificant arm injury to himself during that chase. So in this case, 2 police officers vehicles have been rammed during this chase. You can see that the airbags deployed and that the front of the car is damaged. This is the truck that the defendant or the target was in at the time, and this is the inside of that vehicle. Officers shot at the driver of this vehicle after, again, 2 police vehicles had been rammed. This is the inside of the truck. Something that we often hopefully have to present to the grand jury is the body camera of each of the officers, as well as during a police action shooting, they will collect the firearms of the involved officers and do what we call a round count. So they will look inside of the gun and see how many are left inside of the magazine and take a picture of it so that they know how many shots may have been fired on scene. Officers, just as any other person under our Constitution have the right not to incriminate themselves, and often don't give statements that night or ever, unless they are brought before the grand jury to testify. So in this case, the only way that we knew how many shots were fired was by doing a round count of each of the officers' magazines and their weapons. So in this case, the other two witnesses that we would have called would have been the other non-shooting officers. There were two that were on scene that day that could, both during the chase as well as showed up shortly after shots were fired. They each would have been examined. And as we've discussed, we often, in every law enforcement grand jury that I have participated in and that Ms. Frangus has participated in, we have used an expert in police tactics. We hire an expert to give us their opinion on whether or not this was within the generally accepted police practices to have fired these shots, because as the grand jurors are in their instructions are given, they officers have both the right to self-defense as any other civilian in our world has, but they also have there is a statute that gives police officers kind of an extra right to self-defense if they are executing a valid arrest, or there's a couple other if they're executing a valid arrest, or if they see a forcible felony happening before them. And that police expert that we hire will look at everything that we have. They will talk about the use of force training, review the evidence, and then give us an opinion as what they are looking for when they make a determination of whether or not the actions of the police officer were within the generally accepted police practices. They will look at the tactics that were taken. They will also look at whether or not the threat was complete, and whether or not officers, that the risk to an officer is complete between, that is immediate and necessary to use lethal force. And so then those target officers, again, we've told you that they oftentimes do not give statements right away, but they can in front of the grand jury. So if they choose to testify, they're often accompanied, in every case that we have done, accompanied by an attorney. The attorney has read the oath, the target's read the oath. They are reminded that they have their Fifth Amendment right not to speak, but they may choose to waive that if they choose to testify in front of the grand jury, and then they are questioned by the prosecutor as to why they did what they did that day. Again, the defense attorney can be in the room and can listen, and if the officer wishes to take a break to consult his attorney, he certainly can, or she certainly can, but the attorney may not say anything else in the room. And so at the conclusion, same thing, is there a true bill or not a true bill? I think we've talked about this and we are running long, so we will certainly stop here. But again, the investigative grand jury is bringing someone in who may or may not be cooperative in an investigation.
All right, let's give it up for Ann and Amy. I saw people taking furious notes. Was that to stay awake, or were you really engaged? Yeah, there is a quiz at the end of this. So with that, we always want to open the floor up to questions. First of all, I think I have a question for all of you. Does anybody have an interest in serving on a grand jury? There we go. You'd automatically be excluded, but yeah. It really is an interesting process, and it gives you an opportunity to get real-time feedback about what you're working on, how people maybe perceive different issues and different things. As I mentioned before, kind of the greatest change I have seen is in the issue of self-defense in terms of what people think is reasonable under the circumstances. I think a lot of that can be attributed to our gun laws and the fact that there are more people walking around carrying firearms. And so that subjective and objective belief about what is reasonable under the circumstances has certainly changed over the course of the last 20 years that I've been a prosecutor. And it's been a really useful tool to have the grand jury to help us walk through those issues in front of people from the community to tell us and help us define what is reasonable under the circumstances. And so with that, by a show of hands, does anybody have any questions for us? Yes, sir.
Having been a witness in a homicide case, I was the only person to see the two shooters leave the premises, and I saw them from two different windows. And I'm wondering, there was a lag in time when the police came back and took more photos, and I don't remember where it stood in the timing of the grand jury. But can the grand jury say, go out and take more photos from this distance or this angle, and supplement like photo evidence?
So one of the great things about the grand jury is the grand jurors actually lead the process in terms of they have the ability to ask questions. And if they think that evidence would be helpful in making a determination, if we ask the judge, is this something that you think we need to do, Your Honor, and they tell us we do, then that's something that absolutely we could do to supplement the proceedings to provide them with additional evidence or information to help them make that determination. For us, we want to make sure the grand jurors get it right. And so if they are involved in that decision-making process and they feel like that's going to help them reach a conclusion, in particular when we're talking about issues of reasonableness, we want to give them all the tools available to them to be successful.
Well, and that, real quickly, in that case, it seemed like the questions that came to me were, where were you standing and what could you see? And it's like, I hadn't seen the crime, but I was the only one that could put them together with some other things.
Sure.
So, yeah, something happened and police came back out and took more photos from my office, and of course nobody told me why.
But now you know why. We can't tell you. Nobody's trying to be rude. Yeah. Front row, one of our all-time favorite guests here at the CJA.
Got a couple quick questions and one maybe not a little bit longer. And I think I just kind of missed these first two. So can evidence that is obtained by a grand jury be used in an actual trial?
Yes.
Shared with them?
Yes.
Okay.
Absolutely.
Secondly, can a prosecutor or defense attorney, again, I think I missed this at the beginning, can they reject or strike a potential grand juror?
So the way it works during the voir dire process is the defense is not there because, again, we don't know what cases are going to be presented, but we have the ability to strike grand jurors. And sometimes it's because people, because of scheduling issues, cannot commit to the amount of time that we're going to need. But other times, maybe people have different perspectives or biases where maybe they wouldn't be a good fit for that grand jury, and we have the ability to remove people and strike people, same as you would in front of any other trial. And so the judge ultimately has the authority or the ability to say this person maybe should be struck for cause, and that occasionally does happen as well.
And then last question, so suppose a person is subpoenaed and brought in front of the grand jury, but they still choose not to participate and answer the questions. Are they charged with obstruction of justice or contempt or something like that?
This is my favorite part. So the question is, what happens if someone says, you know what, I'm just not going to answer your questions? And so the first inquiry is, does the person have a legitimate right not to answer your question? The most common one is, does this invoke my Fifth Amendment right against self-incrimination? Meaning, if I tell you the answer, I'm going to be incriminating myself. And if there's a determination that no, there's no Fifth Amendment issue there, then we bring them in front of the judge, and the judge says, I'm ordering you to answer the question. And then if the person does not answer the question, the judge can hold that person in contempt. It is civil contempt, and so they can be fined, or they can be fined and or imprisoned for up to 180 actual days. You get no credit time under the contempt statute, and so you could serve 6 actual months for the contempt. And I've been a prosecutor for 20 years. I've seen it a handful of times where people have refused to answer questions, and the judges have actually sentenced them to jail time.
Great. Thank you, Ryan.
Oh, Mr. Stowers.
First, thank you all for this presentation. Just a quick question. Is there data showing a demographic breakdown of those who get indicted during the grand jury process?
And by what do you mean by that? Like when you say demographic breakdown,
From a racial standpoint.
I don't think
I
that
don't know
we
if I guess from a publicly available standpoint.
there wouldn't be, and part of the challenge is we're not, like, if you're not indicted, we're not allowed to say anything about it. So if we have a grand jury in Ray, the original investigation into Greg Stowers' debauchery, if there's no true bill in that, meaning there's the grand jury decides not to indict, no one's ever going to know about it. So we wouldn't be able to say, hey, we brought X number of people in front of the grand jury. Yes.
Are these rules consistent from county to county?
Yes. So
Pretty
this
much?
is all governed by state statute.
Okay, and
So
what about state to state? Are there any differences?
there's a ton of differences. And I know probably the most about the New York process. One of the biggest differences between New York and Indiana is we're allowed to get in hearsay testimony. And to oversimplify that is we don't always have to call the actual witness. A detective can say, I talked to this person and this person told me this. In New York State, you cannot do that. Hearsay is not allowed, and so they would have to actually call every single witness, which significantly extends the amount of time it takes that cases can kind of languish or exist in the grand jury process. So amongst state to state, there's a number of differences in terms of what that procedure looks like. Does it have to be unanimous? Some states it does, other states it does not. And then how often the grand juries are convened is also varies greatly by state to state. There's another question. Yes.
Oh, I know. You say that the grand jury is selected by the same process as a regular jury. Does the same timing thing apply as far as I know? Like I recently, a couple of years ago, served on a jury, and so I won't be called again for a certain period of time. Is that include grand jury?
Yes.
Okay.
Yep. So you're off the hook.
For how long?
What is it, a couple of years?
2 years.
2 years.
You can choose if you are called within the 2 years and you want to be a juror again.
Oh, okay.
You
I thought
can
just
be.
wouldn't even call me.
You
Okay.
you can use it to get out of being a juror.
Thank you.
So if a grand jury is convened or paneled and they come back with not a true bill and additional evidence comes out later, because I assume there's no double jeopardy, they can reconvene another grand jury?
No. So we are bound by that decision. So once you go through the grand jury process and the grand jury renders a decision, it's over, it's done with. And we have to move on. And then we don't have the ability to charge it. So if a grand jury says, hey, we're not going to indict, I couldn't say, well, let's charge it anyways because I disagree with the grand jury. You have to live with whatever determination the grand jury makes. So you really do take it out of the hands of the prosecutor. Yes?
So in Indiana, is it typical for a target of a grand jury to be able to do it by Zoom?
No. So if you are a target, you need to be in person. And I don't think we've had not a target.
No, we have had witnesses testify by Zoom.
Right. Yes. Go ahead. Yeah.
So I understand all the privacy issues that you want to talk about in most cases. In this case, where you're talking about an example of its history, why is there a privacy issue?
Neither of these cases went through the grand jury.
That's what I'm saying.
Yeah. So I mean the whole point of the grand jury process is until you are formally accused of a crime, you are entitled to a presumption of innocence, and that presumption of innocence requires secrecy, where we don't want people speculating as to what the grand jury may or may not be investigating, or who they may be investigating, and that idea of secrecy kind of trumps all other concerns, which is why this is one of the few areas of the law where if you don't follow the secrecy provisions, it's a crime, and people are.
But if it goes to the grand jury after the process, so when the person is indicted, why is it continuing? The secret form doesn't change.
So it's less secret in the sense that the person who is the target now gets access to all of that information. The court gets access to all of that, and then all of that evidence is going to be used in a trial that is open to the public.
So you could use one of those cases as examples of this.
If it went to trial. Yeah. Right. Oh, I thought you had your hand up, Jade. Okay.
Since you served for 90 days or 3 months or quarter, about how many cases would a grand jury see in that period of time?
Yeah, it really just depends on what we have going on. I mean, we've had really active grand juries that have heard a ton of cases, and then other times, for whatever reason, there's just not a lot going on. It really depends on just kind of where we are in our investigations with different issues. What's the most you think you've done with a grand jury period?
Maybe like 7, maybe 7 would be the most, maybe more than that. Sometimes we do investigative ones, and those may be one witness for 2 hours. And so it's kind of, we can do several of those in one day. But probably in that like 7 to 9 range the most, and sometimes it could be 1 or none, depending if nothing comes about during that quarter.
Okay, thank you.
What is the advantage of using grand juries in white collar cases in particular? Why are they more common in those types of cases that I would assume have more like documented evidence?
Well, so, one of the things that you always struggle with in criminal law, in particular as it relates to white collar cases, is number one, oftentimes you're walking that fine line between civil and criminal. What is a civil dispute and what is a criminal dispute? And when does this go from a contractual issue to theft or a criminal sanction? And sometimes you need the grand jurors to help sort that out. The other part is, and I'm not trying to be funny here, but they are incredibly boring and they are difficult to present to people. And one of the reasons you want to put it in front of a grand jury is you want to know what works. How can we get people to understand this complex financial scheme? And again, you want that feedback from the community where they're going to say, hey, we understood this part of it. We didn't understand this part of the case. And so it really helps you develop a better understanding of not only the strengths and weaknesses of your case, but how do you want to synthesize that information and convey that information to people in the community if you ultimately go to trial. So it's also a good opportunity for us to kind of get that community feedback of are we doing a good job of explaining what took place here, and is it criminal in nature?
When questioning people as prospective grand jurors, how hard is it to dig out or to meet out the biases that may be hidden? Are people pretty quick to admit that they have them?
Sometimes yes, oftentimes yes, sometimes no, but we're pretty good about kind of being able to read people's body language or their faces when somebody else says something, and then that can kind of it can kind of clue you in, like, I think there's more there to ask that person about. But yes, some people do, keep things to themselves, but most people are pretty outspoken about their thoughts.
Yes, sir. Are we talking about 404B, like prior bad acts? So the question is basically one of evidence in terms of prior bad acts, and are prior bad acts admissible during the grand jury? One of the things that we try to do is what would be admissible at trial, and ultimately we are in the position of where our legal guide is the judge. And so the legal advisor for the Marion County Grand Jury is a Marion County judge. And so we could go to a judge and ask that question. We don't want to put in a lot of 404 or what's commonly referred to as prior bad acts because we want people to evaluate that situation, that circumstance in that moment in time, as opposed to saying, well, because this person did something bad before, they must have done this. That's the forbidden inference, and that's something that we try to stay away from. And so you still want to adhere to the rules of evidence, and you only want to present evidence that you have a reasonable expectation that's going to be admitted at trial.
And our other question is, how does it impact the stop case when you celebrate?
What
I know they cited from the Supreme Court was that 93 Thompson in the United States found use of drugs for weapons, and they used that as an actual case law. But it was never said in what was said from the grand jury how they indicted this was a criminal case here or in certain states.
I don't have a good answer for you on that. I don't know. Yes, sir.
Does the hearsay law
testify only to the grand jury?
Yes, so if we went to trial, you can't get into hearsay, but during the grand jury, you have the ability to use hearsay. So one of the most common places that you use that is on a lab report. You get a gun and the gun matches the bullets or casing that are found at the scene. You call your detective and you say, "Detective, did you get a report from the crime lab? What did the report from the crime lab say?" At trial, you couldn't do that. You would have to actually call the examiner who examined it, and they would have to come in and testify and say, "I examined those firearms, I examined the bullets and the gun casings, and they do in fact match." Yes?
Are grand juries using a bulk of the police action shootings that happened?
I don't know if I would necessarily say the bulk of them, but they are certainly used in a pretty significant percentage of grand jury proceedings. One last question. We got one more. Yes?
Do you ever impanel a grand jury from a different county if a case is very, very controversial or heavily covered?
Yeah, so one of the things that you have to do is, and I think they covered it, is one of the questions we ask, if we know that we're going to present a specific case, we ask people, do you know anything about this case? And it's not only done before we select people, but when we tell people when they come into the actual grand jury conference room and before we start to present evidence, we have that question of, we're going to present this original investigation. Does anybody know anything about the facts of this case? And then if people do, then we go into a further inquiry to see what they know, how much they know, and is that going to influence their ability to hear cases. In the entire time I've been in the prosecutor's office, I cannot think of one single instance where we had to take something out for a grand jury, but I do suppose it is possible if there's a case that was high profile enough. Okay, you are a third of the way towards a free t-shirt, which I know everybody's super excited about. I cannot wait for next week's presentation, which is a real life case that happened here in Marion County, involving a serial killer that we successfully prosecuted here in Marion County. For anybody who likes true crime podcasts, this is way better than those podcasts because we're actually going to tell you what happened, how we put the case together, and how we were able to successfully convict an individual who was involved in another number of homicides, not only in Indiana, but in Tennessee and Ohio and maybe Alabama. So there's a lot of really cool things that we're going to discuss next week. I look forward to seeing everybody same place, same time, next Wednesday. Look forward to having that discussion. Thank you for being here.
Thanks.